His Excellency Mr. Vuzimuzi Mandozela to the podium.
Mr. President, distinguished members of the Court, this is both an honor and a responsibility of monumental proportions to appear before you today on behalf of the Republic of South Africa for the second time within 41 days. Mr. President, while South Africa's foreign policy has always favored a two-state solution, the prevailing conditions suggest that unless such an approach deals with the inequitable offering of land to Palestinians, the dismantling of all the illegal settlements, the right of return to all Palestinian refugees, such a solution may solidly lead to the disenfranchisement of the indigenous people of Palestine and concretize the prevailing injustices brought about by decades of apartheid settler colonialism. A just solution for all who legally qualify to live in historical Palestine would need to be negotiated with the assistance of the international community. The inordinate delay in achieving a fair and just settlement has resulted in an unending cycle of violence. A clear legal characterization of the nature of Israel's regime over the Palestinian people can only assist in remedying the ongoing delay in achieving a just settlement. In this regard, on the legal questions placed before the courts by the United Nations General Assembly in Resolution 77/247 of 30 December 2022, we wish to make the following submissions. South Africa cannot overstate the significance of this advisory opinion for the Palestinian people, more especially the legal characterization of the situation of occupation and the imposition of the system of racial oppression and apartheid, which have unconscionably been permitted to continue for far too long. The occupation alone has persisted for 56 years. As the UN Special Rapporteur on the occupied Palestinian territories explained in 2022, the occupation by Israel has been conducted in profound defiance of international law and hundreds of United Nations resolutions, with scant pushback from the international community. Consequently, Mr. President, that defiance by Israel has already led to the killing of tens of thousands of Palestinians, including an estimated 30,000 killed in the past 4 months alone. These are not mere statistics, Mr. President. They are flesh and blood of the Palestinian people. Therefore, we must ask, when will Israel's decades-long impunity for widespread and systematic human rights violations and violations of peremptory norms of international law end, if not now? Over the past 136 days, the world has watched in horror, daily, the relentless attacks on Gaza, the ferocity and violence of Israel's latest military campaign against Gaza, and its flouting of international law, including an order of this court, which was handed down on 26 January 2024, is the clearest indication that Israel considers itself unrestrained in its actions against Palestinians. Its actions recur with even more depravity and bloodshed, being of such a serious nature as to lead this court to find them plausibly genocidal. I remind the court that it is in our recent submissions before it, in the hearings for the indication of provisional measures in the application of the Convention and Prevention of and Punishment of the Crime of Genocide in the Gaza Strip in South Africa versus Israel, South Africa underscored how Israel's ongoing acts and omissions in Gaza form part of a continuum of illegal acts perpetrated by it against Palestinian people since the 1948 Nakba, and since then the 1967 occupation. The legality of that occupation is now the subject of this matter before the court. Mr. President, the Palestinian cause is one which resonates strongly with the people of South Africa. That is because the Palestinian struggle invokes mournful memories of our own struggle against apartheid, segregation and oppression. Ours is an experience aptly referred to by the United Nations Security Council in 1980 as a crime against the conscience and dignity of mankind, and as being incompatible with the rights and dignity of man. It is not without a measure of irony that one notes that this painful experience of our past has enabled South Africa to make a significant contribution to the development of international law on apartheid. From this experience, a universal legal prohibition of its practice emerged in the form of a peremptory norm and an international crime. The norm against apartheid has become one of the most cited norms of jus cogens. We as South Africans sense, see, hear and feel to our core the inhumane discriminatory policies and practices of the Israeli regime as an even more extreme form of the apartheid that was institutionalized against black people in my country, coincidentally from the year 1948, and which lasted until 1994. The late South African cleric, the Most Reverend Archbishop Desmond Tutu, wrote the following, open quote, "Many black South Africans have traveled to the occupied West Bank and have been appalled by Israeli roads built for Jewish settlers that West Bank Palestinians are denied access to, and by Jewish-only colonies built on Palestinian land in violation of international law. Black South Africans and others around the world have seen the 2010 Human Rights Watch report, which describes the two-tier system of laws, rules and services that Israel operates for the two populations in areas in the West Bank under its exclusive control, which provide preferential services, development and benefits for Jewish settlers while imposing harsh conditions on Palestinians. This, in my book, is apartheid. It is untenable," end quote. That was the position already 14 years ago, since 2010. Since then, the situation of the occupied Palestinian population has worsened exponentially, with the reality of apartheid becoming so obviously explicit as to now being recognized not only by South African and Palestinian victims of apartheid themselves, but by the broader international community, including both Israeli and international human rights organizations. Moreover, it is clear that Israel's illegal occupation is also being administered in breach of the prohibition of the crime of apartheid. It is indistinguishable from settler colonialism, which has no place in the 21st century. Israeli apartheid must end. Palestine, the last unfulfilled sacred trust of civilization, for whom the international community bears responsibility, must now be fulfilled. The Palestinian people must be permitted to exercise their inalienable right to self-determination. Mr. President, South Africa bears a special obligation both to its own people and the international community to ensure that wherever the egregious and offensive practices of apartheid occur, these must be called out for what they are and brought to an immediate end, and that the perpetrators of such egregious breaches of peremptory norms of international law be held accountable. In the construction of wall case, this court held that the construction of the wall being built by Israel, the occupying power, in the occupied Palestinian territory, including in and around East Jerusalem, and its associated regime, are contrary to international law, and that Israel is under an obligation to dismantle forthwith the structure therein situated, and to repeal or render ineffective forthwith all legislative and regulatory acts relating thereto. Despite that 19-year-old finding by the court, today Palestinians in the West Bank, including many in East Jerusalem, continue to be contained behind a segregating wall. They continue to be subjected to discriminatory land zoning and planning policies, punitive and administrative house demolitions, and violent Israeli army incursions into their villages, towns, and cities, and refugee camps, including Area A, which is supposed to be under full Palestinian control. Palestinians continue to be subjected to routine violent Israeli raids on their homes, with thousands of adults and children being subjected to unlawful arbitrary arrests by Israeli soldiers in the dead of night, and indefinitely renewable internment without trial, known as euphemistically as administrative detention, and a dual legal system pursuant to which Palestinians, including Palestinian children, are tried under military legislation by military judges, often themselves illegal settlers, in Israeli military courts, without basic protection of international humanitarian and human rights law, while Israeli settlers living illegally in the same territory are subject to an entirely different legal regime and tried in Israeli civilian courts with full access to due process. Separately, Palestinians in Gaza have lived in a sealed-off enclave, fragmented and segregated from the West Bank, and subjected by Israel to regression, sustained closure, and seized. Palestinian refugees and exiles in the diaspora are systematically denied their right to return to their homes. Apartheid Israel discriminates against and fragments all Palestinian people to ensure the maintenance of Israeli Jewish domination. South Africa beseeches this court to examine the institutionalized regime of discriminatory laws, policies, and practices applied by Israel along the definition of the crime of apartheid, and to find that Israel subjects Palestinians to what constitutes an apartheid regime. The clear legal characterization of the nature of Israel's regime over the Palestinian people can only assist in remedying the ongoing delay in achieving a just settlement, a delay which perpetually conflagrates the cycle of violence. As I speak, and for each of the past 136 days, the world is witnessing in Gaza an assault that is unprecedented in speed and severity, violating the most basic precepts of the right to life and the survival of a population. The international community's unwillingness to hold Israel accountable for its policies and practices, and its failure to ensure the immediate, unconditional, and total withdrawal of Israeli troops and an immediate end to Israel occupation and apartheid in Palestine, including Gaza, the West Bank, and East Jerusalem, emboldens Israel to cross a further threshold, namely to commit the crime of crimes, genocide. Mr. President, distinguished members of the court, it is now my honor to request you to invite Advocate Andrew Stemmet to the bar to submit South Africa's further observations on the questions referred to the court by the UN General Assembly. Thank you.
I thank His Excellency, Mr. Vuzimuzi Madonsela. I now give the floor to Mr. Peter Andreas Stemmet. You have the floor, sir.
Mr. President, distinguished members of the Court, it is an honor to appear before this Honourable Court today on behalf of the Republic of South Africa. The request for an advisory opinion presents a critical opportunity to clarify and reconfirm the rules and principles of international law applying to the situation of Palestine and the Palestinian people. A clear legal assessment would assist the General Assembly and the broader international community to promote peace and justice, a key element of judicial propriety, at a time when a ferocious and unrestrained military assault has been launched by Israel on the Palestinians in Gaza, which this court has found may plausibly amount to genocide, threatening the very existence of the Palestinian people. In this submission, we do not intend to restate South Africa's arguments on why the court has to assume jurisdiction, as this has been dealt with in some detail in our written statement. We will therefore focus on the Palestinian right to self-determination and the violation thereof by Israel, and then we will continue to submit our arguments on the legal consequences for Israel, the United Nations, and third states. Mr. President, members of the Court, the right to self-determination, also called the Magna Carta of decolonization, is an established and inalienable right in and fundamental principle of international law. The respect for this principle is one of the purposes of the United Nations, Article 1, Paragraph 2 of the Charter. It has an erga omnes character owed to the international community as a whole, on which the Court has developed a strong and consistent jurisprudence. The inalienable right of the Palestinian people to self-determination and full independence has been recognized by the United Nations in numerous resolutions over the decades, and the most recent General Assembly resolutions of December 2023 once again recognized the right of the Palestinian people to self-determination and the permanent sovereignty of the Palestinian people in the occupied Palestinian territory, including East Jerusalem, over their natural resources. Self-determination accrues to a people, and in its most recent order of 26 January 2024, in the matter of application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel, the Court confirmed that the Palestinians constitute, and I quote, a distinct national, ethnical, racial, or religious group, end quote. Israel has occupied the Palestinian territory in the West Bank, Gaza, and East Jerusalem since the 1967 Arab-Israeli War, and annexed East Jerusalem and parts of the West Bank in that same year. It is not disputed that the acquisition of territory by the threat or use of force is illegal, irrespective of whether the territory was acquired through a war of self-defense or of an act of aggression. The occupying power cannot annex any part of the occupied territory, and there is an obligation on states not to recognize such an illegal territorial acquisition. Moreover, that an occupation must also be temporary in nature was confirmed by the Court in the Namibia Southwest Africa case, where it held that the end of South Africa's mandate must be self-determination and independence of the people of Namibia. A 56-year occupation is not temporary. Annexation, per definition, cannot be temporary. These principles also apply to Palestine. The Security Council has already in 1967, in Resolution 242, expressly emphasized the inadmissibility of the acquisition of territory by war and called for the withdrawal of Israeli armed forces. Furthermore, in the construction of a wall case, this court unequivocally held that the ongoing construction of Israeli settlements in the occupied Palestinian territory is in breach of international law. However, it is clear that Israel has turned the temporary nature of the occupation into a permanent situation, in violation of the Palestinian right to self-determination. It has done this through its illegal settlement enterprise, which now consists of an estimated 700,000 settlers, an increase of 235% since the Oslo Peace Accords, and of 165% since the Wall opinion. That is notwithstanding that in the Wall case, this court unequivocally held that the ongoing construction of Israeli settlements in the occupied Palestinian territory is in breach of international law. In that case, the court found that Israel has taken measures that, and I quote, severely impeded the exercise by the Palestinian people of their right to self-determination, unquote, in breach of that fundamental right. The very disruption of Palestinian territorial integrity resulting from those settlements, as well as Israel's formal and de facto annexation of parts of the occupied Palestinian territory, including East Jerusalem, constitute further violations of that fundamental right. General Assembly Resolution 1514 of 1960 declares in paragraph 6 as follows, and I quote, any attempt aimed at the partial or total disruption of the national unity and territorial integrity of a country is incompatible with the purposes and principles of the Charter of the United Nations, unquote. The court, in its advisory opinion on legal consequences of the separation of the Chagos archipelago from Mauritius in 1965, held that the Resolution 1514 has the status of customary international law, and hence is binding on all states, including Israel. Mr. President, members of the court, turning now to the nature of the Israeli administration of the occupied Palestinian territory, it is straight law that Israel, as the occupying power, is bound by both international humanitarian law and international human rights law in its administration of the occupied Palestinian territory. The basic objective of international humanitarian law applicable to occupation is the protection of the population under occupation, including their safety and security, and their public and private property. As the record of the past half-century makes clear, Israel, as the occupying power, is not acting in the best interests of the population under occupation and is not administering the occupied territory in good faith, breaching multiple jus cogens norms of international law, including the prohibitions on annexation, self-determination, apartheid and genocide, on which I have focused. In terms of international humanitarian law, the continuing construction and expansion of Israeli settlements in the occupied Palestinian territory are in clear violation of Article 49 of the Fourth Geneva Convention, to which Israel is a party and which the court has found in the Wall case to be binding upon Israel. In terms of international human rights law, this court confirmed in the Wall case that the protection offered by human rights conventions does not cease in the cases of armed conflict, except under specific and very defined derogation principles. While it's also established law that the human rights law obligations of a state also apply in situations over which such state has control. Mr. President, members of the court, Ambassador Manoncela has dealt in some detail with the practices of apartheid perpetrated by Israel against the Palestinian people, including as the occupying power in the occupied Palestinian territory. But at this juncture, it's also appropriate to recall that the court held in the Namibia South Africa case that to establish and enforce distinctions, exclusions, restrictions and limitations exclusively based on the grounds of race, color, descent or national or ethnic origin constitute a denial of fundamental rights and is a flagrant violation of the purposes and principles of the United Nations Charter. The extent of human rights violations and discriminatory laws and practices by Israel with respect to the Palestinian population is well documented in various reports of the treaty-based and charter-based mechanisms of the United Nations and is recalled in the resolutions of the Security Council and the General Assembly. These policies and practices have reached the threshold of apartheid within the meaning ascribed to it in the International Convention on the Suppression and Punishment of the Crime of Apartheid. While Israel is not a party to the Apartheid Convention, the fourth report on peremptory norms of general international law, jus cogens, by the International Law Commission Special Rapporteur, found that the Apartheid Convention codified what was already a crime under customary international law, and that this crime has a jus cogens character. The prohibition of apartheid and racial discrimination is therefore a peremptory norm of international law and binding on all states, including Israel. Mr. President, members of the court, Israel's total disdain and disrespect for these principles result in the occupation being inherently and fundamentally illegal in terms of international law, just as South Africa's prolonged presence in Namibia was found by this court to be illegal. Mr. President, members of the court, further to a finding of illegality, the General Assembly also seeks guidance on the wider consequences of such a finding. We now turn to the legal consequences for Israel, the United Nations, and third states. The continued occupation by Israel and the Palestinian territory, including East Jerusalem, as well as the aforementioned violation of peremptory norms of international law, are breaches of international obligations constituting internationally wrongful acts attributable to Israel and which invoke the law of state responsibility. The law of state responsibility provides that the state responsible for an internationally wrongful act is under an obligation to seize such act and to make reparation in an adequate form, as confirmed by this court's predecessor in the factory at Khorzhov case. In the present case, the aforementioned principles of international law require that Israel must bring an immediate, unconditional and complete end to the occupation in all its manifestations. This means that Israel must immediately cease its illegal settlement activities and all measures aimed at altering the character, status and demographic composition of the occupied Palestinian territories and dismantle illegal structures, including the settlements and the wall. Furthermore, it must immediately, unconditionally and totally withdraw its occupation forces from the occupied Palestinian territory, dismantle the settler colonial apartheid regime against Palestinian people, rescinding all legislative measures adopted with a view to annex Palestinian land and discriminate against the Palestinian people, allowing for the full restitution of Palestinian property and for the right to self-determination of the Palestinian people to be finally realized. The United Nations, especially the Security Council and General Assembly, must in all their engagements and actions on the issue of Palestine be guided by the imperative of the implementation of the sacrosanct Palestinian right to self-determination. To this end, these organs must use all measures within their powers to bring an immediate end to the unlawful Israeli occupation of the Palestinian territory, including Jerusalem, East Jerusalem. The United Nations should also remain seized of the matter and continuously monitor implementation of any order that the court may give to end the racial discrimination and apartheid by Israel in the occupied Palestinian territory, to ensure that the illegal situation is terminated immediately, and to ensure that their resolutions are implemented without delay. Urgent consideration should also be given, in particular, to the re-establishment of the Special Committee on Apartheid, with respect to the occupied Palestinian territory that will be seized with this matter. Third states must immediately act with a view to end, through all lawful means and measures, the annexation by Israel of parts of the occupied Palestinian territory and East Jerusalem, and refrain from rendering assistance or aid in any form to Israel for the maintenance of the situation. Third states have a positive obligation not to recognize Israel's continued occupation and presence in the occupied Palestinian territory, as these are breaches of jus cogens norms of international law. That obligation, far too long ignored, must now urgently be implemented. Mr. President, members of the court, the failure of the international community to act decisively to end the illegal occupation and annexation of Palestinian territory and the settler colonialism, apartheid practices and continuous human rights violations perpetrated by Israel against the Palestinian people as an occupying power across Gaza, the West Bank, including East Jerusalem, form the broader context and the root causes of Israel's current military onslaught on Gaza that has already claimed the lives of an estimated 30,000 Palestinian civilians and has resulted in wide-scale destruction and a catastrophic humanitarian situation. Mr. President, honourable members of the court, It's often said that the right to life is the font from which all other rights flow. The same could be said about the right to self-determination. In the absence of self-determination, it is impossible for a people to realize a plethora of other rights. These advisory proceedings present this honourable court with the opportunity to assist in bringing about the immediate and unconditional end to the ongoing unlawful violation of the Palestinian right to self-determination. Mr. President, distinguished members of the court, this brings to an end the oral submission by South Africa. I wish to thank the court for your attention. Thank you.